Chapter 5. Deposits. Question 4. Answer in brief. 4 marks each. 1. State the amount of deposits that different types of companies can collect by way of deposits. Answer. Companies Act 2013 contains certain terms and conditions for different companies to accept deposits from its members, directors, and public, and the same are as under. A. Private company. A private company can accept deposits from its members, or directors, or relatives of directors, up to 100% of its aggregate of paid-up share capital and free reserves. However, as specified by the Companies Act, certain class of private companies can accept deposits more than 100% of its aggregate of paid-up share capital and free reserves. B. Public company, other than eligible company. A public company, other than eligible company, can accept deposits from its members or directors. However, it cannot accept fresh deposits if the amount of such deposits, together with the amount of previous deposits, exceeds 25% of the aggregate of the paid-up share capital and free reserves of the company. C. Eligible public company. An eligible public company can accept deposits from its members and public. In case of deposits from the members, it cannot accept fresh deposits if the amount of such deposits, together with the amount of previous deposits, exceeds 10% of the aggregate of its paid-up share capital and free reserves. In case of deposits from public, it cannot accept fresh deposits if the amount of such deposits, together with the amount of previous deposits, exceeds 25% of the aggregate of its paid-up share capital and free reserves. D. Government company. A government company can accept deposits from public, not exceeding 35% of the paid-up share capital and free reserves of the company. 2. State the contents of circular or advertisement for deposit. Answer. A circular is issued when the company invites deposits from its members, and an advertisement is issued when the company invites deposits from the public. Following are the contents of circular or advertisement for deposit. 1. Statement regarding the financial position of the company. This statement contains all the financial details of the company, like its assets, liabilities, net worth, etc. 2. The proportion of secured and unsecured deposit out of fresh issue. Circular or advertisement should contain clear bifurcation about the proportion of the secured and unsecured deposit. 3. Credit rating obtained from a credit rating agency. This is applicable only to eligible public company. Such company has to appoint a credit rating agency, and the credit rating given by it should be mentioned in the circular or advertisement. 4. Details of the scheme of deposit. All the details of deposit, such as nature of deposit, whether secured or unsecured deposit, tenor, etc., should be mentioned in the circular or advertisement. 5. Name of deposit trustees. In case of secured deposit, company has to appoint deposit trustees. The name of the deposit trustees must be mentioned in the circular or advertisement. 6. Amount due towards any deposits previously accepted by the company. Details regarding the previous deposits, if any, and the due dates of such deposits should be clearly given in the circular of advertisement. 3. State the provisions regarding appointment of deposit trustee. Answer. The provisions regarding appointment of deposit trustees are as under. 1. Eligible companies and public companies are required to appoint one or more deposit trustees while inviting secured deposits. 2. In case of secured deposit, the company has to create a charge on its tangible assets for an amount not less than the amount of deposit accepted within 30 days of acceptance. The charge has to be created in favor of the deposit trustees. 3. The deposit trustees are appointed to protect the interest of the depositors in case the company defaults in repayment of deposits or interest on deposits. 4. Company signs a contract with the deposit trustees, called as trust deed, containing the terms and conditions of the contract. 5. This deed has to be signed at least 7 days before issue of circular or advertisement. 6. When a company defaults in repayment of deposits, the deposit trustees can call a meeting of all depositors, either on its own or on the request of 1/10 of depositors. 4. States any 4 terms and conditions regarding acceptance of deposit. Answer. There are various terms and conditions regarding acceptance of deposit, and the following are 4 of them. 1. Period or tenor of deposit. A company is not allowed to accept or renew deposit which is to be repaid within a period of 6 months or more than 36 months. However, a company may accept short-term deposits which are repayable earlier than 6 months for the purpose of meeting any of its short-term requirements, provided a. Such deposits have a tenor of minimum 3 months, and b. Such deposits shall not exceed 10% of the aggregate of the paid-up share capital and free reserves of the company. 2. Application form. Company should provide the application form to the intending depositors. It should have a declaration by the depositor that the money is not being deposited out of the funds acquired by him by way of borrowing from any other person. 3. Secured or unsecured deposit. A company is allowed to accept secured or unsecured deposit. This has to be clearly mentioned in the circular or advertising inviting deposits. In case of secured deposits, it has to create a charge on its tangible assets within 30 days of acceptance of deposits. 4. Appointment of deposit trustee. Eligible companies and public companies are required to appoint 1 or more deposit trustees while inviting secured deposits. The deposit trustees are appointed to protect the interest of the depositors in case the company defaults in repayment of deposits or interest on deposits. Company signs a contract with the deposit trustees, called as trust deed, at least 7 days before issue of circular or advertisement.